well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards, and we are once again going to be talking about waiting periods today. You know, we were talking with Alicia Garcia about the 10th Circuit here. Actually, I guess it was District Court, the challenge to Colorado's 3-day waiting period. Well, that case might get to the Supreme Court, but there is another waiting period challenge that is going to get there first. In fact, it's already there. Beckwith versus Fry is a case out of the First Circuit Court of Appeals that challenges the 3-day waiting period that lawmakers in Maine put in place a couple of years ago. District Court judge, correctly, in my opinion, held that 3-day waiting period violates the Second Amendment because there is no cooling off period that you can find in our history of gun laws and regulations. Not until the 20th century, anyway. This is a thoroughly modern invention, the idea that, well, we need to delay people from getting a hold of a gun just, for their own well-being, right? You didn't find that in 1791 or 1868. But the First Circuit Court of Appeals, we talked about this with Jim Wallace from the Gun Owners Action League before, may be more hostile to the Second Amendment than even like the Ninth Circuit. So they reversed the district court decision. They stayed the injunction that the district court had granted and determined that Maine's waiting period law doesn't even implicate the Second Amendment. They didn't have to look to history. The state of Maine didn't have to try to find analogous laws from 1791 or 1868 in order to justify this cooling off period because the First Circuit said, well, this is just a condition on the sale of a firearm. And the Supreme Court said in Heller that conditions on the commercial sales of firearms are presumptively constitutional. So therefore, this is presumptively constitutional and, no injunction. Well, in the cert petition authored by Erin Murphy, she and the plaintiffs point out the fallacy of the First Circuit's argument, and they do so in a very good way. So the question that they present to the Supreme Court is whether forcing law-abiding citizens who have already passed a background check to wait out a multi-day cooling-off period before taking possession of a firearm violates the Second Amendment. And again, I think the answer is yes. They point to the 10th Circuit in their cert petition, because as we talked about with Alicia Garcia, the 10th Circuit, which has jurisdiction over Colorado, also has jurisdiction over the state of New Mexico. And in a case called Ortega versus Grisham, the 10th Circuit Court of Appeals ruled that New Mexico's 7-day waiting period violates our Second Amendment rights. State of New Mexico asked for an en banc a review of that decision. The 10th Circuit denied en banc review, allowing that 3-judge panel's decision to stand. And the state of New Mexico did not appeal to the Supreme Court. They didn't want to. And I suspect that if Colorado loses its case, that the gun control lobby will prevail on Colorado's Attorney General not to appeal that decision, to just take the loss, keep that loss confined to the 10th Circuit. So Beckwith versus Fry, the First Circuit case, really is, I think, the best opportunity for the Supreme Court to resolve this circuit court split. Because gun control groups are going to try to play keep away from the court here, right? I want to quote pretty extensively, actually, from the cert petition because it's so good. Paul Clement and Erin Murphy, I think, are Second Amendment rock stars. We talked about this before, but in 2022, Paul Clement and Erin Murphy, they were the plaintiffs, or they were the attorneys for the plaintiffs in the Bruin case. And after that decision came down, the firm that employed Paul Clement, now think about this, he won a huge victory at the Supreme Court. Right? And it may be that we think it was the obvious decision. Well, the right to keep and bear arms includes the right to bear arms. But that was a major victory. And to celebrate, the firm that Paul Clement worked for said, we're not doing any more Second Amendment cases. Basically, our guy's too good, and we don't like the outcome. So Paul Clement left. He could have continued making big bucks and just decided my days as a Second Amendment litigator are over. He didn't. He and Aaron Murphy went out, hung their own shingle, Clement and Murphy, and they are handling, I don't think exclusively Second Amendment cases, but they are handling a lot of Second Amendment cases. So I have a great deal of respect for Paul Clement and Aaron Murphy, just from a Second Amendment advocacy standpoint. But I have to say also, I love reading their briefs. I think they're both fantastic writers. They are able to really get to the point without a lot of extraneous clutter, without a lot of legalese. It's very easy to understand. It's very easy to follow along. So, I just want to quote from the beginning of this petition for certiorari. Aaron Murphy writes, in most of the country, once someone passes a background check and confirms that she may lawfully possess a firearm, she can take possession and begin exercising her constitutional right to keep and bear arms without delay. That's no small matter. When it comes to defending oneself and one's loved ones, time is often of the essence. Take, for instance, the victims of domestic violence served by the petitioner Andrea Beckwith, a survivor herself, who has dedicated her life to empowering women in crisis and helping them obtain the tools and training they need to feel comfortable defending themselves. Or the couple who sought to purchase a firearm from petitioner A&G shooting after they suffered a home invasion. Or the young woman harassed by a stalker who came into the store after local police advised her to buy a firearm, since police are an hour's drive away from her home. Yet, owing to a recent Maine law, individuals facing such dire straits are left defenseless for at least 3 days. Section 2016 of Title 25 of the Maine Revised Statutes mandates a so-called cooling-off period of 72 hours on nearly all firearm sales. It makes no difference why a Mainer seeks to buy a firearm, or if she has a concealed carry permit or a hunting license. Doesn't even matter if she faces an imminent threat and needs a firearm to defend herself and her children now. Everyone must wait at least 3 days, even after passing a background check, before they can take possession of a new firearm, on the theory that even people who have demonstrated their law-abiding bona fides cannot be trusted with their constitutional rights. As we talked about yesterday, this applies to people who already possess firearms, not just new gun owners. You can have 18 guns at home. You can have 200 guns at home. If you try to buy the 201st, well, you're going to have a cooling off period, right? As Aaron Murphy writes, nothing in our nation's historical tradition supports this kind of paternalistic prophylaxis on prophylaxis, which is at odds with the very premise of the Second Amendment, that people can be trusted to keep and bear arms unless and until there is a reason to think otherwise. To be sure, she writes, our nation's tradition of firearm regulation recognizes that the government may keep firearms out of the hands of citizens who have been found to pose a credible threat to the physical safety of others. That's why laws that are designed to ensure only that those bearing arms in the jurisdiction are in fact law-abiding responsible citizens typically will pass muster. But our nation's tradition has never endorsed efforts to broadly restrict arms use by the public generally, let alone to do so on the reasoning that the bare desire to exercise that right makes someone suspicious. And Maine's law falls decidedly in that camp. Indeed, a law that requires nearly everyone to cool off for days before they can keep or bear a firearm and does nothing else is the very model of an unconstitutional effort to deny ordinary citizens the fundamental right that the Second Amendment secures. Murphy then gets into the 10th Circuit decision in Ortega, contrast that with the First Circuit's decision in Beckwith versus Fry, and says that squares circuit split The constitutionality of cooling off laws is reason enough to grant certiorari. But the disagreement among the circuits does not end there. Nearly every circuit has rejected the First Circuit's view that laws regulating the acquisition of firearms are presumptively constitutional, at least unless they completely ban people from acquiring a firearm. And the Ninth Circuit, hardly a bastion of Second Amendment rights, has done that consensus one better, holding that a law temporally metering the ability of law-abiding citizens to obtain new firearms not only is presumptively unconstitutional, but lacks even a distant historical cousin. That is a reference to the case Wynn versus Bata, which struck down California's gun rationing law, their 1 in 30 law, which I believe has now been replaced by a 3 in 30 law because California lawmakers just don't get it. Actually, they do get it. They just choose to willfully ignore what the courts have to say about a right to keep and bear arms. From there, Aaron Murphy describes extensively why this is not a presumptively lawful commercial regulation, right? The sale has already taken place. You've passed the background check. You've paid your money. Now you have to wait. Now, there's nothing that happens during that 72-hour period that will impact that sale. It's not like the state, well, let's just double check and do another background check. No. It's just that the clock has to tick for 72 hours. That is not a condition on a sale of a firearm. That is a condition on the possession of a firearm. And that implicates the plain text of the Second Amendment. Now, the state of Maine had argued, all right, well, listen, even if this is not just a commercial restriction on the sale of a firearm, even if the Second Amendment is implicated, there's a national tradition of doing this type of stuff, right? Because back in the day, back in 1791, people often had to wait much longer than 3 days. What if they ordered a firearm, but the firearm wasn't there at their local store, so they had to wait for, a ship to come in? That's the same thing. No, it's not. No, it's not. First of all, that's not a condition imposed by the government. That's a condition imposed by the nature of travel in the 18th century. There was no law that said, hey, if a gun is in stock, you still got to wait 6 weeks, just like you're getting over from England. No. That was not a condition of possessing a firearm. It was not an imposition imposed by the government. The how and the why of Maine's law, instituting an artificial cooling off period for the purpose, again, of requiring gun owners to cool off, is ahistorical. Again, it is a 20th century invention. It has no analog in 1791. It has no analog in 1868. The only analogs to Maine's waiting period law are the other, relatively recent waiting periods in places like Colorado, California, right? Those laws come far too late to serve as historical analogs. As Aaron Murphy writes, no state for 200 years forced law-abiding citizens to wait out an unadorned, paternalistic cooling off period before they could acquire a firearm. She says cooling off laws like Section 2016, again, are a thoroughly modern invention, even as compared to administrative waiting period laws. She says that's not because the problem that Maine claims Section 2016 is intended to solve, preventing impulsive suicides and homicides committed with legally purchased firearms, arose only in recent years. There have always been people who want to get their hands on a weapon to cause immediate harm to others or themselves. But there was no tradition, not at the founding, not in the Reconstruction era, and not for the better part of the 20th century, of making people cool off for a set number of days before they could take possession of a firearm, let alone of imposing a cooling off period on people who already passed a background check. And again, who already possess firearms in many cases, right? She says that Maine has never contested that the few waiting period laws of the early 20th century were designed to give licensing authorities time to conduct background checks, not just to make people wait to cool off. Nor has it denied that the first law imposing an unadorned cooling off period came in the 1990s. Instead, she says, Maine argued that Section 2016 is analogous to historical laws that restricted people's ability to use or acquire firearms when intoxicated, and to 20th century licensing and permitting laws. Murphy says, as the 10th Circuit explained in rejecting those same strained analogs in the Ortega case, the scope and underlying justifications for such laws were vastly different from a cooling off law like Section 2016. Restricting people's ability to use or acquire firearms when intoxicated. Maine's waiting period law bears no resemblance to that. You can be a teetotaler. Alcohol cannot have touched your lips. You're still subject to the 3-day waiting period, right? The 20th century licensing and permitting laws, well, no. Because again, you've already passed the background check. You've already been cleared to purchase that firearm. You've already paid the money in many cases, right? You just can't take possession of that gun. So if this is akin to a licensing law, then you've got your license, but you still can't get your gun. The only way, the only way that this can be upheld, in my opinion, is again by treating this waiting period as if it is a condition on the sale of a firearm. But it's not. Because the sale has taken place. The transfer just can't be completed. Why? Because the state says so. Because the state assumes that you don't really need a firearm. And that really is what it boils down to. As Erin Murphy writes in the closing of the cert petition, indeed, she says, Maine has been remarkably forthright about its judgment. In its view, everyone is better off without, quote, a firearm as part of their safety plans. So it's really doing people a favor by disarming them in their times of greatest need. That paternalistic judgment stands in marked contrast, she writes, to the framers' decision to elevate above all other interests the right of law-abiding responsible citizens to use arms for self-defense. Our ancestors would never have accepted a law so openly premised on distrust of those seeking to exercise that right. And she says, this court should grant certiorari and reverse the First Circuit's decision and provide a much-needed reminder that it is for law-abiding responsible citizens to decide how best to defend hearth and home, not for states to decide whether a firearm is really worth insisting upon. So, what are the odds that the Supreme Court takes Beckwith versus Fry? I would like probably a little bit better than the average case, right? And again, the Supreme Court takes about 1 in every 10,000 cert petitions. So the odds of them taking any particular case really long. I am not as concerned. You know, the court has already granted cert to Viramontes and the Connecticut so-called assault and ban challenge. Higgins versus Lamont, I believe. A couple of years ago, I said, okay, because they took that one or those 2 cases dealing with the one issue, who were probably not likely to see the court grant any more Second Amendment related cases. I don't think that's the case now. We saw last term Hamani and Wolford, right? So we know that they can take multiple cases. Beckwith versus Fry is up on a preliminary injunction appeal. Ordinarily, again, or at least in terms past, I would have said, well, the court likes to wait until these cases have been finally adjudicated. They've had a trial on the merits. But Wolford was another case that was up on preliminary appeal, the Hawaii vampire rule case, and the Supreme Court granted cert there. So I think given what we've seen from the court in the very recent past, those two qualifications are not necessarily knocks against the court granting cert here. They have taken more than one Second Amendment case. They've taken cases that were up on preliminary injunctions. And there is that circuit court split, which I do think matters. We saw that in Wolford, where most of the courts around the country had said the vampire rule was unconstitutional. The Ninth Circuit said Hawaii's was not. The Hamani case, you had several different splits about how to interpret Section 922G3, the unlawful use of drugs and the prohibiting of owning firearms. Well, you've got that circuit court split here between the 10th and the 1st, but also the 10th, and I believe the Ninth Circuit has adjudicated this issue and has upheld California's waiting periods. So I think that there's a decent chance that the court will hear this case. Now, they won't discuss it in their first conference for the fall term. They'll come back. I think the first conference is September 28th. The state of Maine will have, I believe, 30 days to reply to the cert petition, and they can ask for more time, and that's routinely granted. So they may choose not to reply at all. If that's the case, I think that you will see at least one justice request a reply from the state of Maine, because I think this is an issue that is going to draw the interest of one or more justices just from the get-go. But it's likely going to be late fall, maybe even early winter, before the court has the chance to discuss this case in conference and decide whether or not it's going to grant cert. I hope that they do. I really do. And not just because, I can say that about virtually every Second Amendment case. But as Murphy's cert petition makes clear, this isn't some theoretical argument, right? We're not talking about, how many angels can dance on the head of a pin here. We're talking about whether somebody who has left an abusive relationship where their abuser has said, if you leave me, I'm going to kill you, can access a firearm for self-defense without having to wait for 3 days. That's a reality. Whether, again, a couple who is the victim of a home invasion, who've now decided, if God forbid they come back, we don't want to be helpless. Can the state say, well, you have to be helpless for 72 hours because God knows what you might do with the gun if we just let you walk out the store right away? Maine will argue that this law is necessary, even if it's not, even if there are no historical analogs, even if it's not imposing a condition on the commercial sale of a firearm. They'll argue that this is necessary because cooling off periods help save lives. And there are some studies that have shown perhaps a slight reduction in the number of firearm-involved suicides in states where these waiting periods are in place. I'm willing to accept that this law may have prevented a suicide. But I don't know that the attorneys for the state of Maine or the lawmakers who passed this law would be willing to acknowledge that this law may also have led to a homicide or an aggravated assault or another crime where somebody was unable to protect and defend themselves or their loved ones because the state had told them, nah, you can't have a gun yet. Even though you passed the background check, even though you paid for it, we're not going to let you have it. There are trade-offs, right? We would probably have a safer society if we didn't have the Fourth Amendment, if police didn't have to worry about violating our due process rights. And I'm sure that if we could actually ban the possession of firearms and get rid of all 500 million that are privately owned, maybe we would have less violent crime. But we would also have less of an ability to protect ourselves. And, by the way, again, unless you wiped out the Second Amendment, you'd be violating our constitutional rights. So, if you're an anti-gun advocate and you don't like this right, work to repeal it. But you can't ignore it. You can't just suddenly decide it means something else. Or that the text of the Second Amendment is no barrier to whatever kind of gun control law you want to put in place. That's not how this works. And the waiting period law in Maine is a barrier to exercising our Second Amendment rights. Particularly, again, for those who are trying to exercise those rights for the first time in their life. All right. Let's move on to today's armed citizen story, somebody protecting their life. Today's recidivist report, our good deed of the day. We'll start with our recidivist report. From Pennsylvania, they were paroled in June for Harrisburg shootings. Now, cops say they tried to kill again. Yeah, and not shootings that took place back in like the 1980s, right? This is from PennLive.com. They say two men charged with trying to kill 4 people in Swatara Township last weekend had been paroled from prison several months ago for their involvement in prior shootings, including one that was a fatal shooting. The 4 victims in this case were in a vehicle that left a bar in Harrisburg. They were going to an after party when the shooting happened around 3 a.m. on Sunday. The investigation led police to charge 21-year-old Asmir Green, 23-year-old Taiwan Bender, and 32-year-old Todrick Newton, each with the 4 counts of attempted homicide. Taiwan Bender and Asmir Green got out of prison in June for convictions in shooting cases, different cases. One was fatal, one was non-fatal. Suspects, by the way, have not been apprehended. They're still on the loose as of Wednesday anyway. So, these earlier cases, Penn Live says Green and Bender were paroled from state prison less than a week apart in June. Green released on June the 3rd. Bender was released on June the 9th. So, Green was 15 years old in November of 2020 when he and a 17-year-old named Keith Moore ambushed a 57-year-old man in broad daylight in a parking lot in Harrisburg. Michael Cox was walking through the parking lot. He was carrying his breakfast when Keith Moore fatally shot and robbed him before the teens ran away. Moore and Green were both charged with murder, but the Dauphin County DA's office dropped the murder and robbery charges against Green in exchange for his guilty plea to conspiracy to commit robbery. It's a first-degree felony. And Green was sentenced to 4 to 8 years in prison. Not 48, 4 to 8 years in prison, followed by 2 years probation. Moore took his case to trial and ultimately was found guilty last year of first-degree murder. So he's locked up for quite some time. Green, on the other hand, a 4 to 8 year prison sentence 6 years ago. He served 6, roughly, of that sentence, 6 years, before he was released on probation. Tyshawn Bender, at the age of 16, was charged in January of 2020 with attempted homicide after police say he fired at an occupied vehicle there in Harrisburg. Bender was sentenced to 2.5 to 6 years in prison on aggravated assault charges. He was paroled on March 19th, 2005. Now, again, the incident happened in January of 2020. He didn't immediately accept a guilty plea or immediately go to trial, right? So at some point, probably later in 2020, maybe 2021, that's when his sentence began. And then he was paroled on March 19th, 2025. But he violated that parole and was returned to prison in June of last year before returning to prison, before he was released earlier this summer after serving the remainder of his sentence. One of the other individuals who's been accused of this crime, Todrick Newton, the 32-year-old, also a convicted felon, not allowed to legally possess a firearm. He was paroled from state prison on a felony drug offense last July. But here you have two teenagers who ultimately were tried as adults, by the way. This isn't a case of a juvenile justice system gone bad, because these teens were both sent to adult court. It's just that they were offered deals and sentenced to less time than they would have been otherwise. Now, I can't even say that Pennsylvania law, let them out particularly early, right? I mean, they served most of the sentences that were imposed on them. Unlike, Illinois, where you basically got a day off your sentence for every day you spend behind bars and you don't assault a guard or kill an inmate. This is a success story for the criminal justice system in Pennsylvania. Justice was supposedly done here in the case of Asmir Green and Taiwan Bender. But I would say that since they got released from prison in June, and here it is August, and the two are once again accused of attempted murder, maybe they should have spent more time behind bars for their previous crimes. All right, on to today's armed citizen story. From the, I believe this is from the South Bend, Indiana area. No charges filed against Colfax Bridge shooting suspect is the headline. As it turns out, the shooting suspect was acting in self-defense, according to prosecutors. So WSBT reports that no charges will be filed against the man who fired his weapon during a shooting at the Colfax Bridge in late July in South Bend. Investigators say a guy named Antonio Anderson allegedly approached a man, and Anderson had a handgun. Court documents show that a conversation, quote unquote, escalated, and then Anderson actually raised his gun, which prompted the other man to draw his own pistol and fire. Anderson was taken to the hospital. Police say that Anderson has a previous conviction for aggravated battery out of Florida, faces charges of unlawful possession of a firearm. He was not shot and killed. He survived the shooting. He will have his first court appearance next month. And again, the individual who shot him, not facing any charges because he was not the initial aggressor. He was responding reasonably to a threat against his life and lawfully deployed deadly force against his assailant. All right, finally today, our good deed of the day. In the right place, at the right time, willing able to do the right thing. A woman in Lee County, Georgia, who helped save a life just the other day while on the clock. Now, Carolyn Golden is not a first responder. She's not a paramedic. She's not a firefighter, not a police officer. She's an employee of the Lee County Probate Office. And a couple of days ago, I guess this was a Monday, she's there at work, and a woman who came into the probate office collapses. According to county officials, Golden, quote, immediately went to assist. And after determining that the woman did not have a pulse, she immediately began performing CPR. She continued to do so until EMS arrived and was able to take over. County officials say that in a critical situation where every second mattered, she acted quickly, calmly, and selflessly to help someone in desperate need, saying that her willingness to step forward during a life-threatening emergency is truly commendable, and calling her actions an outstanding example of compassion, courage, and service to others, saying that she deserves to be recognized for her heroic efforts. And I would agree with that. So, in the right place, at the right time, willing and able to do the right thing to help a stranger in need, Carolyn Golden, we thank you for your very, very good deed. All right, that is going to do it for this edition of Bearing Arms Cam & Company. Just a programming note, I am going to be away next week, so there will be no Bearing Arms Cam & Company until the day after Labor Day. When is that? September the 8th, I believe. But be sure to check out BearingArms.com. Tom Knighton's going to be holding down the fort for me. We're going to have some great contributions from folks like Carrie Sloan, John Petrolino. If there is some earth-shattering news, you may see a post from me. Probably won't see a podcast. I'm not taking my microphone or anything with me. And won't have access to that. But we got you covered for all of your Second Amendment news and information at BearingArms.com. And as always, I want to thank you so much for being a part of the program, for visiting the website, for listening and watching Bearing Arms Cam & Company. It really does make a difference. And so thank you for that. Until we talk again, be well, be safe,